Welcome to the Kyle Rittenhouse files. So, this episode, the first episode, is going to be about Kyle Rittenhouse and whether he is innocent or guilty based on the evidence and my perspective of the evidence of the things he's being charged of, which include Count 1, first-degree reckless homicide, use of a dangerous weapon. Count 2, first-degree recklessly endangering safety, use of a dangerous weapon. Count 3, first-degree intentional homicide, use of a dangerous weapon. Count 4, attempt first-degree intentional homicide, use of a dangerous weapon. Count 5, first-degree recklessly endangering safety, use of a dangerous weapon. Count 6, possession of a dangerous weapon by a person under 18. So that's a lot to go over. It really is. 6 counts. And so, let's just get into the criminal report itself. This was submitted, a criminal complaint was submitted to the Circuit Court of Kenosha County. I did censor his address as well as his middle initial. I mean, it's pretty obvious who he is, but just in case, want to take out any information that personally he might not want out. Now granted, I will be sourcing where I got this all from in the description below. But, so if you don't know what happened, Kyle Rittenhouse allegedly murdered, I say allegedly because innocent until proven guilty, 2 people as well as injuring another, and if the court gets its, or if the prosecutor gets his way, her way, I believe it's a female, my apologies, gets her way, also 2 endangering counts as well, which would easily give him life in prison. I mean, I'm thinking, based off the numbers, let's just look at one of these, what they consider a first-degree murder. 60 years, 65, life. Interesting how this one is 60 years. Okay. So I find the difference between the first and third count. One is intentional homicide, the other one's reckless homicide. So that's the difference. That's 60 years, 65, 125, 137 years and 6 months, 138 years and 3 months if my math's right, plus the life in prison. So life in prison plus 138 years and 3 months. So basically that's 2 life sentences. It's not just simply 1 life sentence, it's 2 life sentences, give or take. Because some people actually argue that if someone dies and then comes back to life, does that mean their life sentence is over? Well, even in this situation, he would still have another 138 and 3 months. Years and 3 months, my apologies. 138 years and 3 months, which is a huge number. Basically, yeah, it's until he dies forever, is what they're going to list it as. They want him there till the day he dies. Forever. So that's a huge charge in itself. There's been bigger charges, obviously, but that's a very big charge. So, let's just get right into this for count 1. Count 1 is first-degree reckless homicide, use of a dangerous weapon. The above-named defendant on or about Tuesday, August 25th, 2020, in the city of Kenosha County, Wisconsin, did recklessly cause the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life. Let's just look into the evidence. Look at the shooting. And this is from Bwompi, and the reason that I'm referencing Bwompi is I could not find for the life of me a video of the first shots, or the first shooting before the first shooting before the second shooting where 2 more people were hurt. Every single one I've seen has had commentary. I looked for the original New York Times one on their website, but the article I saw only had a photo. So we're going to have to go off this, and this video is to point out the fact that several peaceful protesters were firing off guns throughout the entire incident where Kyle Rittenhouse was trying to flee him off. Alright, so let's just get into this. This is a 2-minute video. The video will be in the link in the description, so... So as you can see in this situation, you can see it's a crappy camera. I don't know where if you guys have a instance of a better version of this first shooting, please let me know, because I've seen it in other people's videos, but they didn't link it in the description, so I couldn't go to that direct link. So let me know if you guys have the direct link, because this is a bad camera angle. But I believe this is one of the videos that's used by the New York Times as well. And if you'll notice, there will be a gun right behind, right around here. You'll see smoke coming off from the gun. You'll also notice, I believe that is Rosenbaum right there. And can we get to that point real quick? Yeah, so there's Rosenbaum chasing after, I believe that's Kyle Rittenhouse right there. Again, really crappy photo, but as you can see, he is chasing him down. And that's why they're not calling it intentional, is because he was being chased, I assume. So as you can see here, in slow motion, there's a gunshot, and you can see the rifle is not aimed. Again, pixelated because you're zooming into a bad camera already. He's still looks like he's running this way and not aiming his gun back. Yeah, they say that Kyle's looking around for the gunshot. You really can't tell because it's a very choppy, but you do notice him start to move his head. And this is when the confrontation happens right here. Again, crappy angle, zoomed in, makes it even worse. Okay, let's see if we can get a better... And there it is, right there. Yes, as they're pointing out, very thankfully, right there you can see the smoke go off. So someone did fire a gun. So not only does Kyle know someone's chasing him, know he's potentially being shot at. You can't tell if that's being shot above you or at you. It's just a shot. Oh, thank you. They have another angle. This is the camera I was looking for. Thank you. So there's Kyle running away. Clearly, this is the better camera. Kyle running away right here, and then Rosenbaum in this pile running right after him. So, we'll rewind a little bit. You will see Kyle right there, and then Rosenbaum right there, chasing right after him. Throwing something, which originally was believed to be a Molotov cocktail, but sources have said it was a plastic bag with something inside, whether it was a bottle, which is what people more likely believe, or it was a brick. Regardless, he threw something that could be considered a weapon, so that's important to note right there. Something was thrown in Kyle's direction, as well as the gunshot, which I believe was it was identified who the shooter was. We'll look into that here in a minute together, because I have multiple things to look over. And then there's a reflection of the muzzle flash. Yes, we saw the previous shot. It was right over here. Yes, perfect. They announced it right there. After Kyle's attacked on the ground and gets back up, you can hear several more gunshots in the distance, none of which were caught from Kyle, as he is clearly in frame and not shooting. That's an important thing to note, and I do want to give all the credit to this video to Bwompy, but I have not found... Nope, let's cut that. Because the second video I actually do have right here, so I don't need to worry about the second one. So Bwompy, we're not taking your full video, just part of it. And then people, if you want to see his take on the rest of it, do check out his channel. So an important thing to also note from Richie McGinnis, who is the main witness, this is what was happening right before the shooting happened. And also we will get some of the gap between this interview and the shootings, because Richard McGinnis, the guy performing the interview, is actually going to be a witness in this case. That's why this is so important.
What are you doing out here? Obviously you're armed, and you're in front of this business we saw burning last night, so what's up?
So people are getting injured, and our job is to protect this business, and part of my job is not something if there's somebody hurt, I'm running into harm's way. That's why I have my rifle, because I protect myself, obviously. That's why my med kit.
He also said that the full video will be coming soon, but that was now 5 days ago, and it still hasn't come out, so I'm wondering if Richard McGinnis is having to withhold that video, or if coming soon is longer than he said. It's either it's coming longer than he said, or the prosecution or the defense are trying to withhold that video from coming out because he will be called to court. So that's important to note as well, that we are missing the full interview, or the full video as he says. So now that we've gotten that through, we can now go to Wisconsin Legislature. So to prove that this is the actual document, I just simply copied and pasted it. This is it right here. So we're going to go over the first-degree reckless homicide. So Joseph... So the reason I said take note of the fact that Rosenbaum had thrown something and was chasing Kyle is important, is because if you look at 939.48 self-defense and defense of others, link in the description below, the first section says, a person is privileged to threaten or intentionally use force against another for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his or her person by such other person. The actor may intentionally use only such force or threat thereof as the actor reasonably, that's a big part right there, reasonably believes is necessary to prevent or terminate the interference. The actor may not intentionally use force which is intended or likely to cause death or great bodily harm unless the actor reasonably believes such force is necessary to prevent imminent death or great bodily harm to himself or herself. So that's a lot right there, just in that section. But another thing to read is, if an actor intentionally used force that was intended or likely to cause death or great bodily harm, the court may not consider whether the actor had an opportunity to flee or retreat before he or she used force, and shall presume that the actor reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself or herself if the actor makes such a claim under subsection 1 and either of the following applies. So that's a huge section there. But it's important to note because it's the premise of the self-defense law in Wisconsin. And so, really, it's up to if people can reasonably understand why he shot. And so, with taking note that he was being chased, taking note that Mr. Rosenbaum threw something at him, as well as, if you go, we're going to head right back, and we're going to go to an important part, which is this. The video shows that as they cross the parking lot, Rosenbaum appears to throw an object at the defendant. Then we continue forward on. You can read the entire thing, but I have highlighted parts that are important to note. A loud bang is heard on the video. Then a male shouts, "F you." Then Rosenbaum appears to approach the defendant and gets in near proximity to the defendant when 4 more loud bangs are heard. Rosenbaum then falls to the ground. So that's what's happening. The defendant then circles behind the black car and approaches Rosenbaum. Rosenbaum remains on the ground, so clearly he's either dying or dead. As we know, he eventually did pass away. And some people say that he was there for murder. If that was the case, why would you come back and essentially look on Rosenbaum? And some people say that if he really cared, he would have stayed. But again, I highlight this because this is important for that aspect as well. So another male approaches and the defendant turns and begins to run away from the scene. So based on the wording, it sounds like he runs away from the other male, but we know that male is McGinnis. And something Richard McGinnis says is very important. So Detective Cephris interviewed McGinnis and indicates the following. Before the shooting, McGinnis was interviewing the defendant, as we saw previously. The defendant told McGinnis that he was a trained medic. McGinnis said that as they were walking south, another armed male who appeared to be in his 30s joined them and said he was there to protect the defendant. So clearly he was a part of a group, which interestingly enough, we don't know what happened to the group and why the group did not come to help at any point. It doesn't matter for the court case, but it's a curious question. McGinnis stated that before the defendant reached the parking lot and ran across it, the defendant had moved from the middle of Sheridan Road, which we saw in the previous video, that was thanks to Wampy, middle of Sheridan Road to the sidewalk, and that is when McGinnis saw a male, Rosenbaum, initially try to engage the defendant. So we have initial engagement, therefore making the initial aggressor Rosenbaum. McGinnis stated that as the defendant was walking, Rosenbaum was trying to get closer to the defendant. When Rosenbaum advanced, the defender did a juke move and started running. Again, this is important to note for any counterpoints. He did try to avoid confrontation. He did a juke move and started running. Therefore, trying one other form, he tried one mean, which was running. McGinnis stated there were other people that were moving very quickly. Therefore, being outnumbered, therefore you can make the argument. McGinnis stated that they were moving towards the defendant. McGinnis said that according to what he saw, the defendant was trying to evade these individuals. Again, another emphasis on the fact that he tried another means before the shooting did occur. My apologies. McGinnis described that the defendant had the gun in a low ready position, meaning that he had the gun raised but pointed downward. So essentially, instead of having it flat, pointed straight to the ground, it's slightly tilted up. I wish I had a camera so I could show you that. The butt of the gun would have been at an angle downwards from the shoulder. McGinnis stated that the defendant brought the gun up. McGinnis stated that he stepped back. He thinks the defendant fired 3 rounds in rapid succession. McGinnis said that when the first round went off, he thought it hit the pavement, and this is important because this is where the claim of endangerment to McGinnis was. McGinnis felt something on his leg and first thought was wondering whether he had gotten shot. McGinnis was behind and slightly to the right of Rosenbaum in the line of fire when the defendant was shot. And that's why they emphasize that. They want to catch him with reckless endangerment, which there's a counterpoint in the Wisconsin law that I will bring up here in a second once we get to count 2. McGinnis stated the first round went into the ground, and when the second shot went off, the defendant actually had the gun aimed at Rosenbaum. McGinnis stated that he did not hear the two exchange any words. McGinnis said that the unarmed guy, Rosenbaum, was trying to get to the defendant's gun. That is important. That is, again, another aggressive move. To go for someone's gun is an aggressive move. Now, you can say that he was doing that in self-defense, but he was the initial aggressor. At least from what we see on the camera, he is the initial aggressor. And so that does not make that a self-defense move. But he goes for the barrel of the gun. So now that's another situation, like I said, where Kyle is running out of options. The gun's being removed from him. He tried running away, but Rosenbaum caught up to him. McGinnis said that the unarmed guy, Rosenbaum, was trying to get to the defendant's gun. McGinnis demonstrated by extending both of his hands. He explains it. Detective Cephas indicates that he asked McGinnis if Rosenbaum had his hand on the gun when the defendant shot. This is important. McGinnis said that he has definitely made a motion that he was trying to grab the barrel of the gun. McGinnis stated that the defendant pulled it away and then raised it. McGinnis stated that right as they came together, the defendant fired. McGinnis said that when Rosenbaum was shot, he had leaned in towards the defendant. So that means he was making another forward aggressive movement towards Kyle before the first shot was fired. Therefore, there's a definite argument for self-defense. This is going to be the main focus because if the first one is self-defense, that's an important factor because if the first one isn't self-defense, the rest aren't self-defense. It's as simple as that. The first one is so important for that reason. But let's go. So, based on the evidence that I see and the law itself, I would say he is really protected under the self-defense law. And some people might argue this little part right here, and that's why I have it highlighted. The actor was engaged in a criminal activity. Someone would argue that criminal activity would be him possessing that gun underage. And you know what? You have a point there. But here's another thing that's very important here. A person who engages in unlawful conduct of a type likely to provoke others to attack him, say, people being threatened by the gun or thinking it was an illegal gun, attack him or her and thereby does provoke an attack, is not entitled to claim the privilege of self-defense against such attack, except when the attack which ensues is a type causing the person engaging in the unlawful conduct to reasonably believe that he or she is in imminent danger of death or great bodily harm. In such a case, the person engaging in unlawful conduct is privileged to act in self-defense, but the person is not privileged to resort to the use of force intended or likely to cause the death of the person assailant unless the person reasonably believes he or she has exhausted every other reasonable means to escape. Say, running away. He tried to run away. So even if you argue the unlawful conduct, the criminal activity, the unlawful conduct, subsection 2A, protects him because he can argue that he exercised every other reasonable means. He had run away and the guy had grabbed his gun, which was attached to him by the sling. Therefore, he either has to give up his gun, which he could potentially get shot with, or he can shoot. That's just about the only two options he has. He already got caught up to when he tried to run away. So, that's why that's so important. Also, another note, which I do have highlighted here, is... let me see where it's listed. Oh, here it is. 939.49, Defense of Property and Protection Against Retail Theft. This is against retail theft, so take this with a grain of salt. But a person is privileged to defend a third person's property from real or apparent unlawful interference by another under the same conditions and by the same means as those under which the person is privileged to defend his or her own property from real or apparent unlawful interference, provided that the person reasonably believes that the fact or such that would give the third person the privilege to defend his or her own property. That is, his or her intervention is necessary for the protection of the third person's property, and the third person whose property the person is protecting is a member of his or her immediate family or household, or a person whose property the person has a legal duty to protect, or is a merchant and the actor is the merchant's employee or agent. An official, adult, or employee or agent of the library is privileged to defend the property, so on and so forth. So, this is an important note, because they did say they were told, we'll see this eventually, they were told that, they were telling people that they were defending the property at the request of the person, in which case one could argue that he was an agent or employee of said establishment. And if that's the case, then he's protected under that as well for defending himself, for firing, because he's defending himself and the property. I don't know if that'll make a huge legal case there, but it's something to note for future reference when you hear people say that it wasn't even his property. It doesn't need to be his own property to defend. Just a simple side note. So another thing that's important to note is, if we can go back, if we look at the second count, the second count, first degree reckless endangering safety, use of a dangerous weapon. This falls apart if count 1 falls apart. Why? If this is listed self-defense, then, right here, the privilege of self-defense extends not only to the intentional infliction of harm upon a real or apparent wrongdoer, but also to the unintended infliction of harm upon a third person, except that if the unintended infliction of harm amounts to the crime of first degree or second degree reckless homicide. They weren't dead, therefore that part doesn't matter. Homicide by negligent handling of dangerous weapon, explosives, or fire, first degree or second degree reckless injury, or injury by negligent handling or damage of weapon, is liable for whichever one of those crimes is committed. There was no injury, there was no death, If the first count passes, the second count passes. If the first count does not pass and is found innocent, he's found innocent on. The second count he will be found innocent on, if the jury goes according to the law. So this is important, but not really. As long as people take into consideration this, if they found him innocent on the first thing, then it won't. There you go, simple enough. So now we go to the third count, which is... So the above named defendant on or about Tuesday, August 25th, 2020, in the city of Kenosha, Kenosha County, Wisconsin, did cause the death of Anthony M. Huber, with intent to kill that person. So an important thing to notice is this video right here. This is the video that they're referencing. Alright, and now we get to the second shooting. Graphic warning. I don't know if this will get age restricted. If it does, so be it. Kyle is running away after the first shooting had happened. He's actively trying to go away. You cannot list him as the aggressor in the situation. And that's why that first count's so important. Is because it's the difference between a guy who defended himself being chased and a guy who just killed someone unjustly running away. Someone smacks him upside the head and he loses his hat. So there was contact. So again, he's already been assaulted. He continues to run. And then, I don't know if you can see right there. You're going to notice right there, Kyle trips, falls. Someone straight up, like, I would say it's a Superman punch, but it's more like a Superman kick. They just launch themselves at him. And they don't know who that is. But also you'll notice right here, there's a man with a skateboard who looks like he tripped and kind of hit him with the skateboard. I don't know if his intent was to hit him hard with the skateboard or what, but he does go for the barrel of the gun, and that's important to note. He goes for the gun, as did the previous person, and he was shot after going for the barrel. He was not shot beforehand. He gets shot right there. He was going for the barrel when it happened. You can't really hear the gun. So he fires off at this person a couple times. That's why they're going to try to charge him with reckless endangerment, even though he was assaulted. Then he gets hit with by this person. Not nearly that hard, but he's in the middle of being... He just got kicked in the face by this person, which you'll see in the notes. Weirdly enough, they say that he missed him, even though he clearly made contact. And then he goes to make contact. And they say he jumps over him, but he clearly makes contact because Kyle gets knocked over. And they trip on each other, so you can't say he jumped over him. They did make contact. Whether it was hard contact or not, he did make contact and had the intent of assault. And then this person goes for his barrel of his gun, gets shot. This person, if we can get this in slow motion... So that person goes over him, he hits him slightly, goes for the gun, gets shot. This person surrenders. At least it looks like it's surrendering. He has his hands up. Then, if you notice, right before this guy gets right in front of the camera, he moves right towards the guy and gets shot. You cannot tell me that he did not... He sprints right at the guy, so it's not a surrender. He surrenders and then runs right after him. So he's still the aggressor, because that situation could have stopped right there if he'd have stayed surrendered. There was not a shot fired until this man, who by the way had a gun in that hand, ran right at Kyle and shot him in his gun hand. And then you'll also notice, right here is important as well. There's a fourth person who has his hands up and backs away slowly. And then you notice, no shots fired. If, like some people say, he was there to kill protesters, why would he not fire off on that person? He actively leaves that guy alone and then proceeds to walk he monitors himself, obviously, but he also then proceeds to go right to the police. And that's important. That entire situation is important because they are saying something that contradicts what happened. In a sense, they say some things that clearly don't happen. The third video that your complainant reviewed shows the defendant running northbound on Sheridan Road after he had shot Rosenbaum. The street and sidewalk are full of people. A group of several people begin running northbound on Sheridan Road behind the defendant. A person can be heard yelling what sounds like "beat him up." Another person can be heard yelling what sounds like "hey, he shot him." That one's true. The other one's a call to action, but "hey, he shot him" is true. Your complainant reviewed a fourth video that showed a different angle of the defendant running northbound. In this video, a person can be heard yelling, "Get him! Get that dude!" Another call to action. Then a male in a light-colored top runs towards the defendant and appears to swing at the defendant with his right arm. In the video we saw, it was the guy who knocked his hat off. The swing makes contact with the defendant, knocking his... Never mind. The defendant continues to run northbound. On the video, a male can be heard saying something of the effect of, "What'd he do?" Another male can be heard responding something to the effect of, "Just shot someone." Then a male can be heard yelling, "Get his..." The defendant then trips and falls to the ground. As the defendant is on the ground, an unidentified male wearing a dark-colored top and light-colored pants jumps over the defendant. I found this odd because they say he jumps at and over, but we clearly say they make contact, so he doesn't jump over him. He jumps at him and can contact with him and then goes over him afterwards. They say jumps at and over as if he did make contact, but we clearly see the reason he went past him was because he tripped on him. Or contacted him and went past him. But he does not, the way they describe it makes it sound as if he was not with the intent to attack. Based on the sounds of gunshots on the video and the positioning of the defendant's gun, it appears that he fires 2 shots in quick succession at this person. It appears that person was not hit as he runs away from the defendant. And big note here, he doesn't fire at that guy again. He does not fire at the guy after he runs away. A second person, who was later identified as Anthony Huber, approaches the defendant, who is still on the ground on his back. Huber has a skateboard in his right hand. When Huber reaches the defendant, it appears that he is reaching for the defendant's gun. That's an important note right there. With his left hand, as the skateboard makes contact, I find it interesting that they actually admit that he makes contact with this one, but not with the previous, which is the colored pants guy, light colored pants guy that wasn't shot. When Huber reaches the defendant, it appears that he's reaching for the defendant's gun with his left hand as the skateboard makes contact with the defendant's left shoulder. Huber appears to be trying to pull the gun away from the defendant. The defendant rolls towards his left side, and as Huber appears to be trying to grab the gun is pointed at Huber's body. The defendant then fires 1 round, which can be heard on the video. Huber staggers away, taking several steps, then collapses on the ground. Huber subsequently dies from the gunshot wound, which I believe pierced his heart and lung. Certain parts of his heart and lung, I believe. So that shot cannot be considered intentional. That was a fire as someone's trying to grab your gun situation. So I believe under the circumstance that's still self-defense. And then we go to the next. After shooting Huber, the defendant moves to a seated position and points his gun at a third male, later identified as Gage Grosskreutz, who had begun to approach the defendant. When the defendant shot Huber, Grosskreutz freezes and ducks and takes a step back. And interestingly enough, they put this in as well, which makes their case look a lot weaker. Grosskreutz puts his hands in the air. Grosskreutz then moves towards the defendant, who aims his gun at Grosskreutz and shoots him, firing 1 shot. Grosskreutz was shot in the right arm. Grosskreutz appears to be holding a handgun in his right hand when he was shot. What? I don't get this. If you're trying to prosecute him, why would you mention that Grosskreutz has a handgun in his right hand and charged at the defendant? That seems like an open and shut case of self-defense. The guy had a gun and was charging towards you, after faking surrender, so he surrendered, quote unquote, and then moves towards the defendant with a gun, and then the defendant, Kyle Rittenhouse, shoots him in the same arm as the gun. So he shoots his gun hand. That's really good shooting, by the way. He disables the gunman by doing that. That's protecting himself. I don't see why that's not self-defense. So, alright. So we've gotten through the video. We've gotten through the laws. Here's the handgun muzzle. Here's Rosenbaum charging right towards Rittenhouse. And then here's an important thing as well. I was looking at the Milwaukee Journey-Sentinel because the biggest charge I could see him getting is, if we go to this, count 6, possession of a dangerous weapon by a person under 18. Could the suspect carry a rifle legally? Under Wisconsin statutes that say anyone under 18 who goes unarmed or goes armed with any deadly weapon is guilty of a Class A misdemeanor. Important that's a misdemeanor, not a felony. Kyle Rittenhouse, 17, was not old enough to legally carry the assault-style rifle he had. That should be in quotation marks. Assault-style. There's no such thing as assault-style. Anything can be considered an assault-style rifle. But let's just go past that. But John Monroe, a lawyer who specializes in gun rights cases, believes an exception for rifles and shotguns intended to allow people aged 16 and 17 to hunt could apply. Tom Grieve, a Milwaukee defense lawyer who also specializes in gun cases, agreed the exception might apply beyond hunting, but said that part of the law is poorly drafted. He said he would argue to apply a rule that interprets ambiguous criminal statutes in favor of the defendant. So that's important to note. You also need to understand that sometimes laws aren't exactly concise, so multiple people can interpret it in different ways, so someone could argue that. Rittenhouse could be in violation of having a gun within a gun-free zone if there was one covering, for instance, a school nearby. Also, Illinois law requires anyone who owns a gun, any kind of firearm in the state, to have a firearm owner's identification card, but that is only available to someone 21 or older, or someone with a sponsor who is 21 and eligible for a card. Rittenhouse did not own the gun, his lawyer said Friday. That's important. Owns any kind of firearm. Owns. If he did not own the gun, that rule does not apply. Kyle also did not carry a gun across state line. L. Linwood said in a tweet Friday morning, the gun belonged to his friend, a Wisconsin resident. The gun never left the state of Wisconsin. Anthony Cotton, a Waukesha defense attorney, said whether or not Rittenhouse legally possessed the rifle is trifling compared to the homicide charge. Well, obviously, but the argument is that if he didn't break that law, if he didn't break any laws, then there was no reason for them to attack him, because some people argue that the reason that they went for his gun was because they thought it was illegally owned, which, by the way, he was 17. You couldn't guarantee you couldn't tell if he was 18 or 17. So he legally owned that gun as far as they knew. Turns out he didn't own the gun, and potentially he either legally or didn't legally use it. But yes, obviously the homicide charges are a lot more dangerous, but most people believe that most moderate, in the middle kind of people believe that he'll be charged with the misdemeanor but not the rest. While some people believe he won't be charged with any, while some believe he'll be charged with every single thing, and that I've seen people who've commented that he should, quote, fry, which by the way has been illegal in Wisconsin for 150 years, as only one person in Wisconsin has been given the death penalty. So, another question people ask is, why was he in a different state, and why was he in Kenosha? He had no right to be in Kenosha. Well, actually, per his defense team, he worked in Kenosha and had spent a lot of time in Kenosha. In fact, cleaning the school off, cleaning graffiti in which the school had. If you need a link to that, I will also show you that. That is in the New York Times post. I believe. But regardless, I can get you guys the link if you guys want the link of him scrubbing school. It really doesn't matter for the court case, but it kind of matters in terms of why he was in Kenosha, because he is there quite a bit. Because if you notice, Kenosha is only a 31-minute drive. Meanwhile, Chicago, which is in the same state, is an hour-long drive. And another important thing to notice is right here. If you zoom out, all the non-major cities go away. Well, what's nearby? Janesville, Beloit, Rockford, Belvedere, Schwamberg, Evanston, Chicago. Oh, look! Kenosha happens to be the closest decently sized location nearby. Isn't that convenient? He happened to be going to the closest decent sized city. Considering Antioch, Illinois is listed as a village via Wikipedia, it's fair to assume that he wanted to go somewhere that had more jobs, that had more business, so on and so forth, and he wanted to protect the businesses in the city that he worked at, because he was a community lifeguard in Kenosha, Wisconsin. And so, to end it off, I would like to say that I believe he is innocent under current evidence. As evidence comes out, and as the court case goes on, I would be quite happy to change my opinion based on the evidence, but with the current evidence shown, if we can go back, count 1, first-degree reckless homicide. We can just put a, oops, my apologies, that's not what I meant to do. We can put a quite nice big ol' X there, because based on the evidence, I think he's innocent of that. And because he's innocent of that, that lists him as innocent for the second count. Count 3, first-degree intentional homicide of Anthony Hubbard. Based on the evidence, I would say he is innocent of that. Because the man did attack him and did go for his gun. I believe that's self-defense under the law, regardless of if he was if he was committing criminal activity with the rifle. He was still protected because his first instance was running. Therefore, it was self-defense. And if the first one was self-defense and they were chasing him for no reason, then that means the second and third shooting were also justified. Or second and third person who got shot were also justified. Attempt first-degree intentional homicide, use of a dangerous weapon. We have also discovered that, based on the evidence, that is also not guilty. First-degree recklessly endangering safety, use of a dangerous weapon. On the unknown male, I would say, considering that he did try to kick the person, you can argue that this would be the best case for him to fight. But considering he was outnumbered by multiple people, that's important to consider. That there were multiple people charging at him. And so, yes, he might have been able to take that person one-on-one without shooting him. I don't know if you take into consideration the mob, that you can't say it wasn't justifiable self-defense. Because that is important to note, that there was multiple people chasing him when he fired at that man. Possession of a dangerous weapon by a person under possession of a dangerous weapon by a person under 18. Now this one, I would say, I'm sorry, I can't really draw on a laptop. I would say that's the only one I can see him being found guilty of. And because the jury might be and even if it is a coin toss, based on the law's ambiguity and kind of iffy terming and such, if that is correct, and I will trust those lawyers, names listed, so I'm not just pulling that out of nowhere. Based on those lawyers, I will say there's an argument at least that he could legally own that weapon. Or not legally own, but legally carry that weapon, rather. So, if the jury's worried that they will get death threats or their family will be harmed, because this is a big case. It's like the O.J. Simpson case where the jury's going to be a huge thing here. And if the jury feel pressured, I guess would be the word, to get him on something at least, I think this will be the thing they will get him for, if they get him for anything. So, that's an important note to make. To do right now is to emphasize at L. Linwood, that would be Lima, India, November, Whiskey, Oscar, Delta. And also, I gotta give him another shout out. Here's my Twitter, by the way, if you're wondering. At selfdefense1776. We go to following. And I believe he's listed. Let me make sure he is, in fact. Yes. At Richie McGinnis. That is Romeo India Charlie. Hotel India Echo. Mike Charlie. Golf India November India Sierra. Thank you guys for checking in and wanting to learn more about this case, wanting to learn more about the Kyle Rittenhouse situation, Kenosha in general. Leave in the comments down below if there's another self-defense case, and what I mean by that is a case where self-defense will be argued, and I will look into it, whether they are innocent or guilty, or if it was self-defense or if it wasn't. Let me know, and these videos will be taking a while. It's not going to be a daily thing. I wish I could do this daily, but this absolutely will take more than a day, because it's taken, I believe, took 3 days to do this video. Almost, not 24/7, kind of 3 days, or 24 hours a day for 3 days. It did take 3 days, though. I would say it took about anywhere from 3 to 8 hours each day of research and getting opinions on not only this situation itself, but the Kenosha situation. Yeah, so follow my Twitter as well if you feel like it. Or don't. But definitely check into the YouTube channel. Like, comment, and subscribe. And another day, another dawn, we shall always have our right to self-defense.